Morning. I'm Rana Dubrow. I'm the CURT Director of Membership, and I'd like to welcome everyone to the CURT webinar on guiding mediation to meet demand, achieving more effective mediation in construction litigation. A special welcome to our speaker, Julia Douglas, shareholder in the firm of Fabianski, Westra, Hart, and Thompson, PA, located in Minneapolis, Minnesota. Julia has focused her practice on construction law. She represents all parties to the development, design, and construction process on matters ranging across procurement and contract formation, insurance coverage, cost and time-related claims, and dispute resolution. Julia also counsels clients on best employment practices and risk mitigation strategies. She has published several book chapters and articles in the construction law area with a focus on mechanics lien claims, bond claims, and effective ADR strategies. Julia has been consistently listed as a rising star and super lawyer in construction litigation in Minnesota. This webinar is being recorded, and a link to the recording as well as Julia's slides will be emailed to you tomorrow. Feel free to post your questions in the chat box, and Julia will respond as we go along in the presentation. At this time, I'd like to turn the mic over to Julia Douglas.
Thanks, Rana, and good morning to all of you. I want to extend a special thanks to the Construction Users Roundtable for asking me to speak to you this morning. We're talking about a topic I feel very passionately about and have spent a lot of time studying and researching. And the purpose of this presentation is really to review a lot of the results of what my research, along with my partner, Dean Thompson, have done in the field of construction litigation and mediation over the last couple of years. So I'm going to share my screen, hopefully here, so we get started. All right. So much information that we get about mediation as a lawyer comes often from our own experiences and from the anecdotes that we hear from our colleagues and our peers in our particular industry, and usually within our own particular area. And while that's useful in terms of trying to figure out what types of mediation techniques are effective and which ones aren't, my partner Dean and I got to a point where what we were hearing from folks here in Minnesota wasn't as broad as we wanted it to be. We ask questions of others so that we can expand our perspectives and increase the universe of experience upon which we can draw knowledge and make decisions when we're giving advice to our clients and their companies. But there are only so many individuals we can ask, and due to the limited pool of information gathered, our perceptions and decisions might be limited. So to address this lack of information, Dean and I decided to conduct a survey of construction attorneys about mediation practices. And I want to share those results with you so that you can also expand your perspective with the help of a broader knowledge base. So what did Dean and I do? Ultimately, we wanted to know whether the mediation preferences of other folks throughout the country matched what we were learning about mediation. And so in our survey, we wanted to ask participants whether mediation has been meeting their expectations, what mediation processes were working for them and for their clients, and which ones weren't. And finally, if there were any concrete recommendations we could start providing to other construction litigators and to their clients on how to improve the process, what would those things be? So in order to do that, we sent out a survey, and we got over 330 responses from construction lawyers throughout the country. We primarily sent the survey to members of the ABA Forum on Construction Law, as well as lawyers at the top 50 construction law firms as determined by Construction Executive magazine. We started the survey during a very auspicious time. in the spring of 2020. And so as you can imagine, with all of the change and flux associated with COVID, we were delighted that we actually got as many responses as we received. Now, we structured the survey with 2 types of questions. The first 17 questions asked respondents on a scale of 1 to 10, with 10 being the highest, how important certain aspects of mediation were to them and to their clients. The last several questions were more open-ended, and they asked the respondents for narrative responses, focusing on what types of mediation practices they found to be particularly effective and which ones they found to be ineffective. How best to break mediation or impasse at mediation, and what types of mediation techniques had changed with the advent of virtual mediation, especially in light of the COVID pandemic.
Julia, I'm going to stop you for a second.
Sure.
I think you may need to change your mode. Looks like you need to go into presentation mode or
That's showing up on my screen, but I don't.
Yeah, I'm not sure if you're.
I think I might have picked the wrong screen, but here, what if I do?
I'm going to say your
Here.
slides aren't advancing.
Okay, hold on. Do this differently. I apologize for that.
You're fine.
Let's do this one instead. That probably looks better, I hope.
There you go.
Okay.
We're seeing the your cover slide.
All
Perfect.
right. And now, so that's the one I just covered. So that's good. All
Thank
right.
you.
So based on the responses we received, our team internally then was able to review the responses in detail and tried to provide or start providing, I think, some concrete ways that we believe lawyers and companies can improve the effectiveness of construction mediation. Now, many of the questions in our survey refer to what we call the standard approach to mediation. And under that traditional method or standard approach, the parties or some sort of dispute resolution service, like the AAA or JAMS, selects a mediator. The parties and the mediator schedule a mediation session for some future dates. And a week to several days before the mediation, the parties exchange mediation statements, either confidentially or with each other. The parties attend the mediation and they keep their fingers crossed to see if it works. And what Dean and I had found, at least in our practice, is that the standard approach really wasn't working anymore. We were showing up to mediation and parties weren't prepared. If you had an insurance company involved, the adjuster hadn't taken the time to adjust or set their reserves. Parties were unfamiliar with what really was at issue, and frankly, so was the mediator. And so we were starting to get frustrated. Now, we realize that most construction disputes do eventually settle. So at some point, this standard approach to mediation works. But for the purposes of our survey and study, we wanted to figure out if there was something we could be doing better and finding a way that we could structure mediation in order to make it more effective and more efficient earlier in litigation. So, as we discovered in our survey, there's a tension involved in mediation. And it's how to strike the right balance between attempting to save dollars and the time and effort that's spent on very costly discovery on the one hand, versus ensuring that by the time the parties arrive at mediation, they've received enough information to make the right settlement decision. So the answers provided in our survey, we believe, can help you tailor a mediation process from start to finish in a way that will help you and your clients achieve receive the information necessary to achieve better mediation results more quickly. And that's sort of the magic way to strike the balance between those two things that are in tension. So the first step in setting up your mediation for success is to choose the right mediator. So one of our survey questions asked respondents to identify the type of mediator that they found to be most effective in their practice. Specifically, we asked respondents to rank the 4 options that you see on the slide in terms of what they believe their efficacy has been in resolving disputes, especially complex construction disputes. The overwhelming preference, I should say, was for experienced construction attorneys. And that's not necessarily surprising because like usually seeks like. However, we believe it makes sense because an experienced construction mediator has the subject matter expertise to really understand and dig into a dispute in a way these other options do not. Consequently, parties will spend less time educating their mediator about the issues in dispute and more time analyzing the respective strengths and weaknesses of their case. Now, in contrast, very few respondents found federal magistrate judges to be effective mediators. Now, we believe one reason for this is that magistrate judges are likely focused on ensuring that discovery and pretrial matters proceed in a timely fashion in their federal cases. And so their focus isn't really setting up a process for settlement. Additionally, the lack of subject matter expertise, especially in the field of construction, can be debilitating and really preventative to finding a resolution. Just a couple months ago, I participated in a settlement conference with a federal magistrate here in Minnesota, and we spent 5.5 hours educating him on just the background of this case, which admittedly is very complicated. But ultimately, by the time the business day ended, there was no time to discuss settlement. And despite the fact that the parties had their insurance companies present and were ready to engage, the business day ended and the session ended, and there actually were no dollar figures even exchanged. All of that time, all of that money, and we have nothing to show for it. And unfortunately, I think, and I don't know what other people's experiences are, but in mine, that is commonly what happens with federal magistrates. So I think in terms of figuring out the right person to guide your mediation, your focus should be on finding a mediator in your area with extensive construction law expertise. That individual is really going to be the best person to engage you and your opposing party, and ideally start to narrow and winnow down the issues that are actually in dispute. Now, after you've picked a mediator, the next key consideration is to figure out when to mediate. And this slide kind of sets forth several different timing considerations that you should consider. One of the questions that I often get is, well, is early mediation just always the answer? And frankly, it depends. No cases, no disputes are ever exactly alike. And I think one of the most important things we can do in our industry is to think and take a hard look as to what our goals and aims are, both for the companies involved and as a lawyer, what your client wants out of a particular dispute. So for example, when asked to rate how important for their construction industry clients it was to maintain relationships with the other party after mediation, the respondents to the survey and rated that goal with an average of 5.7 out of 10, with more than a third of the respondents rating it at a 7 or higher. And this makes sense. A lot of construction companies work with the same project partners. And so sometimes one of the goals or the aims driving the timing of a mediation and potentially an earlier mediation is to preserve that relationship. It's often easier to preserve it if a dispute comes up and you're able to proactively address it earlier on, rather than to go through a protracted, contentious litigation process. right? Similarly, in response to the question of how important it was for their clients to resolve their disputes so that the parties could get back to their businesses, the survey respondents responded with an average response of 7.7 out of 10. So those results also emphasize the importance of providing clients with a way to not focus all of their time, all of their resources on litigation. And certainly these factors in particular would seem to lend themselves to an earlier, or at least a proactive, I should say, mediation process. So one of the key questions, and it relates back to the tension I raised earlier, is how do the parties get their information needs satisfied in order to make a meaningful business decision short of a full recovery at mediation? And so in that regard, designing a mediation process early, even before a lawsuit's filed or shortly thereafter, can often pay dividends. Most parties and counsel acknowledge that the information needed to settle a case is often less than what is needed to litigate it or arbitrate it. And as one experienced mediator has observed after one of my presentations, perhaps 70% of the information needed to be exchanged can be done relatively cheaply. And the remaining 30%, which is usually the most expensive, can wait. Now, a mediator should be able to help the parties satisfy their limited informational needs, preferably on an expedited basis. The goal, we believe, should be to exchange limited and targeted information for settlement purposes. Smart bombs, not carpet bombs, so that what we're talking about is not simply the equivalent of a Rule 34 document dump. So, what types of pre-mediation discovery or information exchange do practitioners find to be most helpful in achieving settlement during mediation? The overwhelming number of respondents, 293 out of the 330, ranked a detailed statement of damages with accompanied backup. So I at least have found that this is frankly the most important. And if you're sitting there thinking to yourself, well, no, duh, you'd be surprised. Often people show up to mediation and sometimes there's just a blanket number being demanded. I want $10 million. Well, where does that $10 million come from? What's the basis for it? Where's the backup of either the damages you've incurred or the delays that you believe have been resulted from X, Y, or Z? And there's no backup. There's no way to meaningfully engage with those numbers. Second highest rated type of information that practitioners believe to be most effective, 200 out of 330, would be an exchange of initial expert reports. And I want to put a caveat on this because I think, for any of the lawyers or in-house attorneys or business people listening to this presentation, you hear expert reports and you see dollar signs. I'm not talking about a full expert report, the type of which you'd see exchanged during litigation. But often when a dispute arises, especially if it's more complicated or if it's going to be worth more money, parties will retain experts right away who can at least provide an initial opinion, maybe just in a couple of pages, as to what the basis of their conclusions are going to be. And I think providing that type of information sort of as a heads up, along with the full settlement and mediation confidentiality protections, is a really good way to get other parties to think about what is going to be argued over in the event that the mediation fails and what the basis for a particular claim or defense really is. And I find that often getting that type of report from a third party, especially an expert who is renowned in a particular field, is more effective than a company's own say-so. So that type of information is also really helpful. Ultimately, most of the survey respondents thought that this type of information exchange should be a process that's really decided by a mediator. Sometimes there are parties who want the entire universe, other parties who don't want to provide hardly anything at all, and probably the sweet spot's right in the middle. A mediator should be in a position to help you tailor that process through early conversation about what information is really going to be needed in order to get the parties up to speed and informed enough to fully participate in this process. Now, based on the survey respondents' answers, the least helpful types of informational exchanges included targeted depositions, production of an entire project file, interrogatories, and requests for admission. So some of the same types of discovery that we as litigators often rely on as a case moves through litigation or arbitration, at the end of the day, it's not the type of information that is necessarily going to be helpful or drive a productive resolution at mediation. Before I transition too much, I want to talk a little bit about mediation preparation, because as I mentioned, at least in my experience, I often show up to mediations and the other parties are unprepared. And so we wanted to know whether that was a phenomenon that other people were seeing across the country as well. And the short answer is yes. The general lack of mediation preparation by parties was shown when all of the respondents were asked whether, in their experience, all of the parties are adequately prepared to participate in a mediation and reach a settlement at mediation, which is obviously the goal. The average response from the survey was a 5.2 out of 10. And I have to say, it doesn't bode well for successful mediation if parties are only prepared something approaching 50% of the time. It's important to note that the responsibility for ensuring that the parties are properly prepared to address issues that are likely to come up during mediation really should fall to the mediator. In my experience, a mediator is in the best position to have confidential discussions with the parties and their counsel ahead of time in order to be able to discover the issues that might come up and potential impediments to settlement as well. The mediator can get parties to start thinking about those ahead of time, and it's a really good way to start preparing them. Yet, when survey respondents were asked whether mediators usually knew the particular impediments to settlement ahead of the mediation, the average score was only 6.4 out of 10. So in order to be more effective at a mediation session and focus on solving the impediments, it's obviously preferable for the mediator to be engaged and to know them well in advance of a mediation in order to ensure that everyone's prepared. The other piece of preparation that's key to consider is insurance coverage. Often in our cases, in order to get the dollars exchanged at a mediation to make a case settle, insurance companies are involved. And they're a really important part of a lot of those cases. So we asked respondents if insurance coverage is involved at the claims at issue, how prepared are insurers to reach a settlement at a mediation settlement? The average response was 4.8, or less than 50% of the time. Given the long lead time that insurers need to make a decision, set their reserves, or change their evaluation of a case, it's unrealistic to expect a substantial contribution from an insurance company at a mediation unless there has been an effort to get them prepared to participate. When counting on insurance dollars to fund a significant part of your settlement, you have to make sure that the foundation has been laid for a recovery well ahead of mediation. And that's another reason for early mediator engagement. So how best to do that? Get my slide to switch here. There we go. We believe the best way to set it up for success is through a pre-mediation conference. So we asked respondents, how often do you have a pre-mediation conference with a mediator? And they said 20% of the time. We also asked participants how important or how helpful a pre-mediation conference was. And respondents said 85% of the time. That's a huge disparity between what we as practitioners have traditionally set up in terms of our mediations and what we believe is actually very helpful and effective. So there's a large gap there between supply and demand. I think the lesson here is to ask for this type of pre-mediation conference upfront as soon as you select a mediator. And you need to make sure that you leave time in your schedule to allow for the mediator to have conversations with each and every party who's going to be attending the mediation. In my experience, it's particularly most helpful and most productive if the parties themselves are involved in these pre-mediation conferences. And so to the lawyers, to the in-house attorneys who are listening to the seminar, invite your client's decision makers to participate. Or if you're the one doing the hiring of the lawyers, ask to be involved. A number of the benefits of a pre-mediation conference are set forth here on this slide. But importantly, it's all comes down to engagement. These early conferences allow a mediator to get to know the parties before they even sit down for mediation. A mediator can talk to companies and clients about their goals, what they want out of the process. It allows a mediator to analyze potential impediments to settlement really early on so that he or she knows walking into the mediation session where the hiccups are going to be. And it ensures that everyone, even those insurance adjusters, are ready and prepared to mediate when the session occurs. And finally, most importantly, one of the ways I think mediators gain more credibility and more leverage is by having these types of conversations. It's really difficult as a client who's been involved in a particular dispute for a long time, or one that may affect whether the business falls apart, to listen to somebody that you've met on day one say, you should compromise and do X, Y, or Z. I think in terms of making hard decisions and in trying to find the right result, it's going to be much better for that client or that company to have a conversation with someone they've met before, with someone who has at least taken the time to really know them and their business in order to get to a point where they are able and or willing to try and compromise their position. We also asked the survey respondents what type of mediation they found to be more helpful or more effective. And the question was really phrased as to whether they had a preference for evaluative mediation or facilitative mediation. So I wanted to find those ideas. In terms of a facilitative mediation, what I envision is more or less a mediator who will go back and forth among the parties and parrot numbers. And when pushed or when asked certain questions about parties' positions, largely just takes the opposite party's line. Well, so-and-so says this, or so-and-so does this. And so they're a conduit for information, but it's basically spitting back and forth what the parties are saying back and forth to each other. And in my experience, that type of mediation is really not going to be helpful. I already have a good sense as to what the opposing party thinks of my case. I want somebody else to weigh in on the issues and where the merits might be. So enter the evaluative mediation. In an evaluative mediation, the mediator provides objective, fact-based assessments on the party's dispute. And it's important to note, again, however, and you're probably sensing a recurring theme here, that this type of mediation can only be effective if the parties are going to be receptive to the mediator's assessment of the case. Ultimately, the utility and the success of an evaluative mediation can be traced back to that pre-mediation conference. And again, it's that kind of conference, that level of engagement that allows a mediator to actually form the relationships and gain the credibility that's needed to really provide assessments as to where the recovery may or may not be. In contrast, in the standard approach that many of us are accustomed to, a mediator only gets a mediation statement a couple of days ahead of time before the mediation session begins. Asking that mediator to credibly assess and objectively assess a dispute when he or she's only known about it for maybe a week is a big ask. And asking them to candidly assess a case based on that very limited exchange of information, and much less getting the clients and the parties to take that assessment seriously, is incredibly difficult. Now, we also asked respondents an open-ended question about what type of mediation techniques they thought were effective or ineffective. And their answers most often fell into these categories. What you see in these responses on this slide with respect to the ineffective mediation practices are mediators that are ultimately unfamiliar with the dispute and unfamiliar with the parties. Mediators who simply shuttle numbers back and forth with very little analysis and very little discussion of what the merits are, in order to press the parties to split the baby, just aren't effective. So by way of example, probably about a year ago, I had a mediation where I represented the plaintiff in a particular case. And the mediator came in and during his very first stop, explained to my client that they needed to be prepared to accept half of their initial demand at the end of the day. And my client wanted to know why. And the response verbatim was, well, this is mediation. This is the time that you compromise your claim, period. No analysis as to why we needed to compromise, much less why we needed to compromise by half. It was, this is the process. This is how it works. If you want it to settle, you will at least need to cut your claim in half. As you can imagine, that type of technique didn't work, and the mediation session crashed and burned shortly thereafter. We also asked survey participants what types of mediation practices are most effective to break impasse, and several of them are listed here on this slide. In case you're not familiar, a mediator's proposal occurs as the parties are potentially nearing an impasse, where the mediator provides each party with what the mediator believes is the dollar figure needed to settle the case, or where it should settle. The mediator provides that number to all of the parties. The parties are then given some period of time, whether it's a day or several, to say yes or no to that number. And they only respond to the mediator directly. If everyone says yes, the case settles for that number. If even one party says no, it does not. So that's what a mediator's proposal is. Bracketing is a type of negotiating where the parties sort of move in ranges. So for example, if I'm the mediator and I say, okay, well, I think the other party will agree to negotiate for a settlement between $500,000 and $700,000. Will you agree to negotiate in that range? And so it's coming up with a range, a dollar range that is effective. We often identified, and participants identified, other mediation practices that they've used to break impasse as well. Most often, it requires follow-up communication with the mediator in order to provide that candid, private evaluation of a client's case. It's important to note here, though, that what all of these options have in common is continued engagement by a mediator who knows the parties. So a guiding mediator, one who's already taken the time to get involved in this dispute and to evaluate the issues, will be in a better position to make a play using one of these methods to break that impasse. And they're also in the best position to continue engagement. So in other words, the mediation doesn't end simply because the session does. So ultimately, what the survey we conducted in 2020 suggests is that you should hire a mediator early, even if you don't schedule a mediation session early on, but to get that mediator to guide the mediation process and to get them ready to participate in mediation and to figure out how best to structure an informational exchange so that everyone is ready to participate and has the information they need to hopefully lead to a settlement. Now, it's not to say that there aren't challenges to this approach. I think, frankly, the biggest challenge is time. It takes time to accomplish the pre and post mediation activity. And if your local areas are anything here like Minneapolis, we only have a couple of really great experienced construction mediators. And so finding the time to squeeze it into their schedule, all of these steps can be hard. It's also hard to make sure that you and your clients can kind of carve out that time too, to find the time to identify what information you need, to find the time to have the pre-mediation conference, and to ensure that everyone is prepared and engaged. Sometimes the challenges of guided mediation really stem from the lawyers themselves. And I admit, as a litigator, I have been guilty of this too. Too often, in my opinion, litigators view mediation as just simply one more deadline in a case scheduling order. Because at least here in Minnesota, we're required to mediate every case that's sued out. And so it just gets put into a scheduling order. This is your date by which you have to mediate, check, check, boom. And we are off to the races in litigation, and we don't actually take the time to want to productively mediate because we're so focused on the litigation or the arbitration and shoring up our strategy and getting through discovery. I think if lawyers are able to take a step back and prioritize a mediation process, it's more likely that you're going to be able to participate in the type of guided mediation I've been discussing, and that ultimately it's going to be more effective for your clients. Finally, it can be hard to get all of the parties to commit to guided mediation. It takes time, it costs money, obviously, to have these conversations. But one way we've started to find in order to help get everybody to the table earlier on is to provide or to include a guided mediation clause in your construction contracts. And so that way, all of the parties agree not only to mediate when a claim or a dispute arises, but the way in which that mediation is going to occur. And my office has started to put together draft language that we often insert into our AIA contracts, and feel free to reach out to me if it's something that you'd be interested in having at your disposal as you start to negotiate and draft your project contracts here for the next season. Overall, though, the survey responses we received overwhelmingly demonstrate that guided mediation is the best and most effective way to resolve clients' disputes earlier and more effectively. Having a mediator who is engaged in this process, engaged with the parties and the decision makers, allows for a more efficient exchange of information and for a better evaluation of the issues in dispute. And ultimately, if a mediation is effective and successful earlier, companies and clients get to go back to work. They get to maintain their relationships with their project partners. And from a lawyer's perspective, you become the person they go to get things resolved quickly. And we should be, and I believe we should be, problem solvers in that regard. Now, not every case settles early, and guided mediation, as much as I'm a proponent of it, isn't always going to be successful. And sometimes you are going to have to move forward with an arbitration or a litigation process. And in that sort of situation, excuse me. One of the things that's sort of becoming a newer trend or a newer way of doing things is a process called mediated case management, which has really been developed and fostered by a guy named Larry Watson down in Florida. And he has found in his ADR practice that mediated case management, which is something short of guided mediation, can also be effective as a way to tailor and make more efficient disputes as they proceed through litigation or through arbitration. So MCM, as I'm going to call it, is usually a process that's under the control of a judge or an arbitration panel. So in this sense, you know, whether a mediation occurs before or after a case has been sued out, MCM always starts after the dispute has been formally commenced. And through MCM, all of the parties, including the decision maker, work together to structure the litigation itself or the arbitration in a way that is either more likely to lead to settlement or alternatively more likely to lead to resolution on certain issues. I think as anyone who's familiar with the construction industry appreciates, very rarely do you have a dispute where there's only one piece in contention between the parties or one issue in contention. And so what MCM aspires to do is to find ways to narrow and winnow down what the parties are actually fighting over. Because if you can resolve certain disputes and then target the few that really are still remaining, you can have then a much more streamlined and efficient either trial or arbitration. And that has a particular benefit to clients too, from a cost and time perspective. So how does MCM work practically? Well, the parties first develop together a stipulated case management agreement, which in a lot of ways looks like a scheduling order with key deadlines for exchanges of information, for depositions, for expert reports, the types of things you usually see in a scheduling order. But it also includes or encompasses a working statement of issues. So what issues are the parties going to work through to try and either resolve or at least try and focus on as part of this discovery? So if you think about a funnel, rather than having an entire project file exchange, for example, if you know that there are 3 or 4 issues in dispute, you are going to target your discovery to those issues and ideally gain consensus through those issues. You put these things together through organized meetings with all the parties. It is very much intended to be a collaborative process. And during that time, you also sketch out what type of role a mediator will play in it and how that mediator will work with the court and the parties to facilitate this process. Typically, once the initial pieces are put into place, there are regularly scheduled meetings, usually about once a month, where the parties kind of see where they are on the schedule and the trajectory. And it allows for the refinement of issues, because I think sometimes when a dispute begins, everybody is angry and pissed about everything. But as you start to go through that initial exchange of information, sometimes the issues either narrow on their own, or they can certainly become more specific and more refined. And part of that process is certainly to make that the case. One of the other things that happens during that process is to find ways in which to move forward on key issues. And there are a couple of procedural options that are highlighted on this slide. So one of those is to have a preliminary hearing on an issue in front of a court or a special master to get an issue preemptively addressed and decided on before the rest of the case follows. The other option that parties will sometimes agree to, especially if there is really more of a commitment to resolve the dispute, is to agree to what is a non-binding or non-adjudicatory process where they retain a separate neutral different from the mediator to issue an advisory opinion on a particular issue. So that person, usually a mediator or arbitrator, is in a good position after reviewing papers and listening to arguments to say, here's, if I were your arbitrator, if I were your judge, here's how I rule on that issue. And often getting that type of non-binding opinion will be enough to help push the parties on to settlement. Now, it's important to note that what I'm talking about is a dual tracked process. So while MCM is very much focused on resolution and still using a mediator through a litigation process, the litigation or arbitration itself is still going. Nobody wants to mediate into perpetuity. And at some point, a dispute has to be resolved one way or the other. And so it's important to note, if you start to consider this type of process, that while some of your energy and attention is certainly going to be spent on that issue refinement or settlement exercise, at the same time, you are going to be preparing for ultimately an arbitration proceeding or a trial, and taking the steps to make sure that you are prepared to do both as the case moves forward. But it's important to note that the benefit of MCM forces parties to consider what issues can be resolved and what issues do ultimately need to be tried. And so there's much less wasted time in motion practice, for example, and much more a focus on what the ultimate merits of the case are. So the benefits of MCM, it's a lot of flexibility. You basically create a process during litigation or arbitration that isn't cookie cutter. It's much more tailored to the parties and what their particular needs are and what the particular issues are. It's a very proactive and involved process. But clients often like it because it requires more engagement and involvement from them, rather than just passing a case off to a lawyer and being called upon when needed or when necessary. Larry in particular, and hopefully most clients believe, if it works, that legal fees are ultimately reduced through this type of process, or at a minimum, they're at least better spent. The parties are able to learn more, accomplish more, and you know, in Larry's experience, he has certainly found that it increases the likelihood of an earlier settlement. And if that happens, that's obviously inures to the benefit of all the parties. But if it doesn't, as I mentioned earlier, you increase the likelihood of a shorter, cleaner trial or arbitration if the case doesn't settle. Finally, a lot of clients believe that when you use MCM and you have a mediator involved and there is a commitment to this engagement in this process, that even if you do go forward into trial or into an arbitration, you're in a better position to maintain those client relationships. It's not done in the same scorched earth approach or the same scorched earth way that litigation, especially protracted litigation, can be. So certainly something else to consider if and when guided mediation doesn't get your dispute resolved. So that's sort of my presentation. I don't know if anyone has any questions at all.
Juliet, just a couple questions.
Sure.
First of all, what are you finding to be the most common dispute in mediation?
Oh gosh, that really runs the gamut. So like I mentioned, I think earlier, here in Minnesota, we are required to mediate every case. So it can be something as simple as, you know, defective construction case to mechanics lien litigation, to claims involving, you know, complex claims involving delays, things like that. At least up here and in my practice, we literally mediate any type of dispute that comes through the door. So different site conditions is another common one. Any instance really where there's a contention as to whether one of the parties owes the other money or not, payment or not.
Great. So thinking about your most successfully mediated case,
Mhm.
other than preparation, which you've definitely talked about the importance of that, what made it the most successful?
Probably, well, obviously the preparation ranks highly. And I think, frankly, having a really good mediator can't be undersold. And I can talk about him now because he retired. There's a guy up here by the name of John Harns who was extremely experienced, extremely accomplished. But what I appreciated about him was that he really was an evaluative mediator. He could sit and he could absorb a ton of information, but was always very candid about what he thought of a particular dispute. And he, I think, has always, he emulates a style that I look for in mediators now. And it's pushing parties and clients to really consider the weaknesses of their case. Because I think too often as disputes get teed up, everyone wants to believe that they are in the right, that they're entitled to 100% of what they believe they're owed, period, end of story. And it is sometimes done best by a third party, especially somebody who is particularly experienced in construction or in the type of dispute you have, to get them to push and to make you think about the risks if a case or a dispute doesn't settle, but also where your weaknesses are. Because, it's human nature, for better or worse, we all have blind spots. And I think having that type of mediator who really engages the parties, but also pushes them, is really valuable and key to getting, especially very difficult, entrenched disputes to be resolved.
Okay. I have a few questions also here. What is the role of the contract in mediation as someone to ignore clauses that are not in their favor, emotional position, or they may find conflicting language, focus areas in various contract sections?
So I come to this from a very biased place. I spend probably 30% of my practice drafting and negotiating construction contracts. And so I can appreciate the frustration when certain provisions are either not consistently drafted or they aren't well drafted, much less if they aren't followed. But at least in a lot of standard form contracts, whether you're looking at AIA contracts or EGCDC documents, or even the consensus docs, you will often find a requirement to mediate. Now, those clauses can be drafted in many different ways. As I mentioned, I'm a big proponent, or becoming a big proponent, of adding guided mediation as part of my clients' construction contracts. But I think the important thing to remember is you should pay very close attention to what those different mediation provisions are requiring. And, there are some provisions that will say, mediation is a condition precedent to the start of any type of claims or dispute process, unless both parties agree to waive it. But I certainly think that if you have a contract that requires mediation and the other party's not abiding by it, you should take as many steps as you can to enforce that provision. Because ultimately, at the end of the day, most jurisdictions and certainly most arbitrators are going to require that mediation process to happen one way or the other. So simply ignoring it or not trying to proactively address disputes at the outset in a way that can lead to resolution seems pretty futile to me.
Okay. And Julia, I have a few other questions that have been sent in.
Sure.
what we're going to do is we'll go to the top of the hour. If we don't get through all the questions, if you don't mind, I'm putting you on the spot here. I will email those other questions to you, and
Sure.
if you can respond, and then I'll include them in the email that goes out to everybody tomorrow. Okay.
No, I'm happy to do that.
Wonderful. All right. How should the cost of litigation play into the process during the mediation phase?
I tend to think it's very important. And again, it's why I'm a proponent of trying to resolve disputes earlier as opposed to later. The cost of litigation can be a very powerful incentive to get a dispute resolved, because that is money, it's real money that you're going to spend on discovery, on those expert reports, on any number of things. And so if you have a mediation scheduled earlier in the process, before a lot of those costs are incurred, it's something that all of the parties are aware of, and it's a savings to them, and it should help them direct more dollars towards a potential settlement than what they would pay if the case went through a full litigation. In contrast, at least up here, if you go by what I call the standard approach, and mediation is simply a deadline in your scheduling order, and you wind up mediating the case after, in particular, all the discovery is done and all the expert reports are written, you will likely already be out hundreds of thousands of dollars, depending on the scale and the scope of the dispute. And so having already spent the money, having already been out the money, there's not as much money to put on the table to actually get something resolved. And people and parties are much more entrenched in their position, and I think more bitter about the process. And so you don't necessarily show up to mediation with the hope that something can get resolved. And so I think that cost of litigation factor is incredibly important. And again, I think if you're weighing the scales, it's a more helpful and more effective factor if you're scheduling your mediations earlier on.
Great. And we have reached we are about to reach the top of the hour. Julia, I want to thank you for your time. I want to thank all of you that have attended this webinar. And as I mentioned, I will be sending out an email tomorrow with the additional Q&A, as well as the link to the recording of today's session and Julia's slides. So with that, thank you, everyone. Have a great rest of the day and a wonderful weekend full of Halloween surprises.